Hello, everyone. Thank you for being here today. Welcome to our webinar on mixed signals, managing product compliance in an era of instability and growing convergence. I just want to get started with a little bit of orientation about the webinar platform before I introduce our speaker for today. The webinar slides are available to the left of your screen, along with a few helpful links if you'd like to explore and learn more about compliance and risks. That can help simplify and accelerate how we can help accelerate your compliance processes. We want this webinar to be as engaging as possible. So please send us any questions you may have, and we aim to address them during the Q&A session at the end of the webinar. If you'd like to submit a question for the Q&A session, use the Ask a Question widget on the left side of your screen. We will also follow up with you directly with any questions we don't answer during the session. We'll follow up with you on those. And then at any time, if you're interested in having a member of our team follow up with you, don't hesitate to use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be sent to you within the next 24 hours. So my name is Carrie Whalen. I'm a Senior Product Marketing Manager here at Compliance and Risks, and we are joined by the wonderful Sarah Jane Dobson. Sarah is a partner at Ashurst and the Global Head of Product Liability and Regulatory Risk at Ashurst. Let me just take a moment to share with you a bit about Sarah Jane's background and her extensive expertise. Sarah Jane is the Global Head of Product Liability and Product Regulatory Risk, Safety and Regulatory Compliance at Ashurst, where she is a partner in London. She specializes in regulatory, litigious, and policy matters across the full product life cycle in product safety, compliance, liability, and in consumer litigation. She has extensive experience defending corporate clients in high-stakes litigation, including high-profile class actions. Regulatory enforcement actions, inquests, public inquiries, and judicial reviews. She acts on regulatory compliance, advertising issues, global product recalls, and corrective actions. Sarah Jane has a degree in science, makes her particularly well placed to navigate clients' highly technical product matters. Her dual legal qualification in England and Wales and Australia, her international experience, and her language skills make her particularly adept at multi-jurisdictional and multilingual matters. She holds leadership roles in prominent industry organizations, including a board of director and chair of international student mentorships, and with the European Commission and OPSS for ICFSO, chair of the international legal issues for DRI, and chair of international class actions for IADC. So before we get started, a quick introduction for those of us joining us for the first time. At Compliance and Risk, our mission is to help ensure global companies have the tools and the information to build safe, sustainable products in a world full of change. And that is exactly what today's webinar is all about. And we're very proud to be the trusted product compliance technology provider for the world's leading brands. We have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of your dynamic regulatory landscape and to prove your product's compliance, protecting your brands, and helping you drive growth. To that end, Compliance and Risk, we have the world's most comprehensive regulatory database with over 115,000 regulations historically available in C2P. And with global regulatory coverage and expertise across over 10 industries, we understand that regulatory compliance does not sleep. So our regulatory team of experts speaks 28 languages, and we are fortified by 30 knowledge partners. Our platform, C2P, is our enterprise software that is designed to keep global organizations on top of regulatory changes and their impact on the world. This includes warning alerts, impact probability, productivity workflows, tools, and so much more. But with that, I want to get to our guest speaker. I'm going to hand it over to you, Sarah Jane.
Thank you so much, Kerry, and for such a kind introduction. It's always wonderful to be able to be part of Compliance and Risks program, and we've partnered together now for almost over 10 years, so delighted to be here. Kerry gave such a wonderful introduction, I don't really need to say more, but today we're going to be talking about a very interesting topic that we're seeing practically in our day-to-day practice, and that is the fact that we're in a very significant period of instability and a growing divergence across jurisdictions. And we're seeing in real time how that is creating very significant challenges for businesses like yourselves to try and stay compliant and to manage your legal exposure. So with that in view, we're talking today about that topic, and we'll be doing so in respect of 6 discrete areas. Those are up on your screen. For context, at the beginning, I will talk a little bit about the team, and the point is not only to talk about how proud I am of the team, but mainly to give you a context of the type of depth and practices that are happening from a legal perspective in terms of comparable practices on the other side of the coin, the claimant side. And then I'll talk a little bit about the context of where we find ourselves today, the modern product, the modern world. I'll look at some of the key disruptors that we're seeing in real time in respect of those types of issues that are happening. And then most importantly, potentially, we'll look at some of the strategies that you might wish to engage with in terms of mitigating those legal risks that we've identified. And then I'll take you through some of the predictions that we might have in terms of looking into our crystal ball and gazing into the future. So just by way of very brief introduction, because as I said, Kerry has really done that, most of you will be more familiar with the remainder of my team or the core team or some of the core team members that are very frequent on this webinar platform and with compliance and risks across the world. We have our core team based in London, Munich, Ireland, Brussels, Australia, and as well as the other 31 offices in the 18 jurisdictions in which Ashurst works. And shortly, with an imminent merger, we'll have 52 more offices with 20 other jurisdictions that also will be added. But really, it's just to say that, as Kerry kindly mentioned, we do the full product lifecycle work, and we do that across the full world, essentially, with 195 jurisdictions within scope. We're sector agnostic, given the size of the team, with about 45 plus individuals who only do products law or who work across this area in the more specialist markets. And I think really, as I said, it's really just to talk about the fact that this is now a very specialized practice within law firms. So you can see we've been doing this for very many years, but overnight there's been a proliferation, I would say, of law firms in particular, and also, which I'll come to talk about later on, litigation funders and specialist litigation farming companies that are really focusing on products law, and products law is a very singular focus. And I think that's a testament to how important this area is overall in terms of a focus as a litigation risk that we're seeing across the world. So I always say for every defendant law firm or every law firm that's acting for defendants such as yourselves, there's going to be a comparable law firm acting on the other side of things, and they're going to be backed by a number of players that are really investing deeply into what is now a very specialist area. So I always just remind companies such as yourselves that that's the area in which we're operating, one that's very topical, very well resourced, and now is recognized more than ever as a very specialist area that is worth the investment and worth the resource that companies on the other side of the fence are pouring into it. So having set the scene there, I want to talk now a little bit about the modern day. And I think the first piece to mention in that respect is today's products. I mean, I don't have to tell you, you're all producing those products or selling those products, that the products that are being produced today are more complex than they've ever been. They're increasingly connected, they're software driven, they have numerous different components that are sourced from all over the world. And of course, there's a lot of different consequences to that, and a lot of different commercial and legal exposures that can come from that structure of product. I was talking to one of my US product liability class action trial attorneys the other day, and he was pointing out to me that, in fact, if you look at a sci-fi fiction, Star Wars, in fact, he was saying that, in fact, all of the products we have today are actually being foreshadowed in Star Wars. So I guess we can look to some other new films to see what we can find about the future products. But the future is here now. We have all these products that are very sophisticated and very innovative, and that's been recognized for some time to throw up a lot of different legal challenges. And one of the other ways in which those products are causing challenges is the context in which we're operating. So I don't need to say this again to everyone on the webinar today. We see the news headlines every day, but there's increasingly a lot happening in the world. And more than talking about the other context, I think one of the most important changes that we've seen recently is what the modern day consumer looks like. The consumer of today is very different to the consumer we saw even 5 to 10 years ago. And over the course of my career, I've seen a really marked shift into the expectations of consumers. And for those of you who have worked on the litigation side of things, you'll know that expectations of consumers is a very relevant test at law, particularly in terms of liability. So that's crucially relevant to everything we're discussing today. And I think it's fair to say that consumers these days have very high expectations of the modern day product. They're very demanding in terms of product lifespan, in terms of durability, the product's sustainability, the product's performance, the environmental performance, and all of that, also with the lowest cost possible. And I think all of us can agree, often those issues are at complete odds with each other and create some internal tension themselves. But underlying all of that is safety and compliance, which of course we're all very focused on in our areas, is implicit. It's no longer an expectation. It's a background sound to all of these other expectations that have layered on top. So we find ourselves today in a very complex environment in which to operate. Within that environment, we've been noticing a few different trends on a number of different levels in terms of product regulation, product liability, and regulatory activity that I think is worth drawing your attention to. And I'm sure many of you will be familiar with this, and it would be interesting if you have any comments in the Q&A or anything to add about your personal experiences, please do. This is just some of the highlights that we've been seeing on a day-to-day basis across the world and across all sectors that we think are really shaping product regulation and product liability landscape. The first, of course, when we're talking about disruptions or impacts to the product law space, and I think this is true for every space possibly, is geopolitical environment that we're currently operating in. And there's a number of different ways in which some of these factors are really impacting on products. And again, you will be very familiar with those operating on a daily basis in producing and selling products. But some of the ones that we're seeing that are causing some of the most issues are, first of all, geopolitical conflicts and instability. The one that jumps out at me there is in respect of sanctions risks in particular, where obviously overnight companies are having to change tack because of the illegality of some practices in terms of certain types of products being banned and sanctioned. And we know that that happened quite suddenly, particularly where a conflict was involved, but it continues to happen and take companies by surprise. And it's not only full products, of course, which would be more obvious, it's obviously the component parts. And I think this lays bare companies' knowledge or lack of knowledge about their supply chain, which we all know is a repeated issue. Supply chain opaqueness or supply chain knowledge is a continual thread throughout all of these issues that we're going to see. But companies have been and continue to be fined significantly and penalised in respect of breaches of these sanctions. Something that's less obvious, though, in the sanctions space is in terms of the inability to perform or seek legal recourse or to have cost recovery, because if a action becomes illegal overnight, essentially, it's very difficult to have a court enforce any issues attached to that for sanctioned parties, and also any claims for damages can be blocked entirely. So that's been quite disruptive, as have some forced exits from certain jurisdictions where it's just no longer able to supply, or where there's been products that have essentially been left with no warranty or support that you might expect to see in ordinary circumstances. That's a problem for everyone in the supply chain, because obviously if one entity leaves or there's no ability to recover against that entity, that has a flow-on effect for others in the supply chain as well. We've all been affected personally, I'm sure, by the reduced global mobility and travel disruptions and reduced cooperation internationally. And of course, this makes it more difficult to move products. It also means there's a focus away from some product safety issues, which one could say perhaps that's a useful change, but I suspect that it's not, because after a while these issues begin to bank up and then they begin to be enforced in a different way, which we'll come to later. There's also more of a tendency towards harder recalls investigations because of this lack of cooperation. So, for example, if there's a very punitive decision taken in some jurisdictions, what we're seeing is that being questioned and asked to be moved across, and in some instances, and in other instances, very different approaches being taken across the world in terms of how to deal with those very same issues that apply equally across all jurisdictions. The issue with trade, tariffs and economic nationalism is also very relevant. Many of you will be aware of the origin rules, reclassification rules, some of the mislabeling that's attached to that, and also just sudden regulatory changes that have been tied to political matters. That goes hand in glove with the supply chain disruptions and reductions in choices that we've seen, with increased defect risks often being introduced by unvetted suppliers. So it remains the case that most of the matters that we deal with are to do with downstream suppliers having an issue with their products, not the named manufacturer. That is an increasing trend, and it's more difficult to stop than ever because of the lack of choice of suppliers, and also, again, because of that lack of visibility. But sitting alongside that is some enhanced due diligence obligations, which you'll all be trying to implement to this day, I'm sure, which are very difficult to push down the supply chain if you're not able to have a free choice, and if it's very difficult to barter to get new suppliers, and if the supply choice is very narrow. So those continue to be issues that we see on a daily basis. Liability for the third-party misconduct is also on the rise. In other words, being liable for the behaviour of others is a continued trend that you'll see crop up in most of the regulatory changes that we've witnessed in the last few years. That's not a trend that's going anywhere. And again, that puts a lot of pressure on those that have named responsibility if they're not able to choose their supply chain and properly negotiate and contract with them in the way that you'd ordinarily see in normal business circumstances. And then from a more economic perspective, the inflation pressure and cost-driven product changes, the reformulation and cheaper materials are often being seen to lead to some safety risks. Again, many of you will be aware, unscripted or unrequested changes to material to lower costs is often one of the lead causes of recalls or product safety issues, and that continues to be the case. That's been a long trend. Also, the concept of shrinkflation, where consumer protection exposure is really at its highest, and as are increasingly misleading claims that are being made in that context or being accused of being made in that context. Perhaps one of the most significant, if not the most significant impact, however, I would say for product law generally is the legislative developments that have happened in the last 10 years. Many of you will be aware that there has been a wholesale review at many different levels of jurisdictions and product level and whole system level in respect of regulations that govern placing products on the market, but also at the back end of liability regimes. And these sweeping reforms that we've seen have impacted almost every piece of legislation and also are being now introduced. So in other words, we're seeing these types of changes bear fruit. What is particularly challenging in this environment for many of you is a number of different behaviours that we've seen during this legislative process, some of which are driven by the legislatures and some of which are driven by industry, or some of which are driven by consumers and or claimant law firms who act for them. I think we're all particularly finding difficult to follow the challenging ad hoc and sometimes unpredictable practices of legislatures when they're making these types of laws. Many of you in the EU will be very well aware of the considerable toing and froing that we're seeing in respective legislation recently, where we're having fundamental changes to scope, application, and even revocation during what is meant to be an implementation period. This is having a very profound impact on a lot of you, I know, because often those such as yourselves who are well invested in product compliance and product safety generally like to get ahead of these legislative developments. And now sometimes companies who have done so are finding themselves penalised where they're suddenly out of scope in respect of these types of legislation. So this is also causing internal cultural changes we've seen, where companies who have these very proactive product compliance practices such as yourselves, when they've been asked to implement these laws proactively, and then being told that they have to change tack, or that these costs are currently not useful because this law has changed, that's having a very profound effect on the trust of individuals within organizations, and something that is really continuing on a daily basis to be challenging for everyone. We also continue to see a divergent approach in terms of the types of regulation that are being taken out or made in respect of certain local requirements. This is even in contexts where there's allegedly harmonization. So again, many of you will be very familiar with the Triman logo saga that's currently being investigated by the European Commission. And of course, another example is the food contact material and rubber component parts. Those types of areas where it's just almost impossible to come to any reconciliation in respect of what you do with those divergent regulations. And that's another problem as well, because it's in practice almost impossible to achieve full compliance. And I think that's a pervasive theme as well across these multitude of regulations being developed. It has to be a risk-based approach that's being taken by companies to know the full regulation landscape and to make some informed decisions based on your personal risk profile to decide how, when, and what you're going to comply with in risk order. And that's going to be informed by the legal risks in part, which we'll talk about at the end of this section. The other trend that many of you have experienced, I'm sure, is the lack of guidance in respect of the hard law that's being developed. And I mean, a very good example is the EU's GPSR guidance that took a considerably long time to produce, but there's ample examples that I could think of that we can speak to. Alongside that is a lack of infrastructure sometimes. Again, those dealing with medical devices in the EU will know that the infrastructure required by the legislative changes wasn't set up by government in time and has introduced significant delays. Another trend that's developing is really this tendency for regulators, or legislators, I should say, to look to the full product life cycle when legislating. So not just talking about certain aspects of the product life cycle, which we've seen before, but really looking from design to end of life. And the new EU batteries regulations is probably the best example of a comprehensive piece of legislation. And I think that marks a change in the market for what we can expect to see in the future. And for those of you who have dealt with your batteries regulation already, you'll appreciate it's not the simplest piece of legislation. So if that's the trend to the future, then I think we've got quite a lot of work ahead of us in respect of what we can expect to see. Another factor that is complex in the current environment is the fact that legislation, or the way it's being developed, is not what I would describe as being within the realms of the traditional product regulatory framework. And by that, I mean that ordinarily in the product regulation framework, all of you will be well versed with the hierarchy of application of that legislation. And what we're seeing now is some obligations that interface with product regulations, particularly ESG type obligations that are created in separate pieces of legislation and that still have impact for products. And that is causing problems on a number of different levels. Firstly, it leads to the problem I've just mentioned. Where does that sit in the hierarchy? How does it interact? What is the application? But it also, in my experience, leads to usually a black or a blind spot in companies, because it tends to sit between multiple functions within a company. And where things do tend to sit between those multiple functions, they tend to be missed, even with the most diligent entities being involved in their specialist areas. If something sits between them, it almost always is the subject of something that is problematic ahead of time. Legislatures are also increasingly legislating ahead of your industry and anticipated industry adaptations. So a good example of that is PFAS. What we saw was a progressive banning or restriction, and that continues to take place. But what was recognized in some jurisdictions is that companies were adapting by using different PFAS groups and families, and that was understood to be taking place in industry. The response by legislatures was to ban whole families of PFAS. And again, I think that's a trend that's here to stay. If the legislative intent is to ban or prohibit something, and that's clear from the outset, increasingly there seems to be an intolerance and a attempt to get ahead of, by the legislature, any type of behaviour that's going against that spirit. And again, we all know that the practical reality is that makes it very difficult to implement if we have to really anticipate that our intentions to slowly move to a different way of working are not as tolerated as they were before. And the last piece I'd say, which is frankly very underestimated, and if I were to say on the company side of things, is probably very underutilized, is lobbying. Now, my competition colleagues and I talk about this all the time because I understand that there's very few restrictions on consumer groups, and there's a lot more restrictions on industry, particularly joint lobbying exercises, and that's an entirely different topic that we could save for another day. But needless to say that a lot of the legislative shifts we've seen recently have been the concerted effort of very extensive lobbying activity from consumer groups. And in my view, it's the same issue that we see in litigation, where you tend to have one unified voice for consumers and consumer industry groups, and then you have lots of disparate voices on the industry side, which essentially can often lead to watering down of the message. Or what you see is that those companies that are very well placed and have strong voices, for whatever reason, don't like to be involved. And I appreciate there's lots of sensitivities around being involved in a consultation or a lobbying piece. And as we've just discussed, there are some restrictions from a competition perspective on that. But it's a very marked trend that a lot of the legislative changes have been provoked by that exercise, by the claimant or consumer groups. One of the best examples I can think of is the EU Product Liability Directive. I was involved in the working party group that reviewed that. And the first conclusion there, as it was usually the case since 1985 when the legislation was first in effect, that the legislation didn't need to be changed. It actually bent and flexed for the last many years, and there was no need to change it. We would create soft law. That was the initial outcome of the current check that led to this huge sweeping reform at product liability level. What happened in between was 5 years of intensive lobbying from consumer groups that obviously completely changed the landscape and resulted in what is unashamedly now described as a pro-consumer piece of legislation. So it's just an important story, I think, that where we talk about being subjected to lots of legislation and having a hard time complying with it, my experience is that a lot of companies, such as those of you listening today, have extensive experience and lots to say, but it, for whatever reason, doesn't seem to make it into the spotlight as much as it does for the consumer groups. And as I've said, there might be many reasons for that, but it's certainly something to think about from where I'm seated. Another fundamental area that's impacting how we're dealing with regulations and product safety and liability is really the behavior of the regulators across the board. And as we know, over the last 5 to 12 years, there's been a shift towards pro-enforcement because for a lot of the jurisdictions across the world, the EU is probably one of the best examples, but there are other examples. It's thought that there's been a really robust system, but lacking in teeth. And so that has been a focus of many regulators across the world for some time now. But what we're seeing with the proliferation of legislation is the fact that, frankly, like us as companies, it's not possible to enforce everything. And therefore, what we're seeing is a really disparate and divergent approach to enforcement across the world. And that can create a really difficult risk profile for companies, where, as I mentioned before, something might be a mandated recall in one jurisdiction and not amount to any consumer-facing action in another. But I think also it just makes what I've described before in terms of risk assessments and deciding what is your path to compliance very challenging, because it's very opaque as to what policy initiatives are happening. It's unpredictable. And frankly, in practice, I find often in terms of enforcement, the professed policy focuses of many regulators in all of their public documents aren't necessarily those which they're enforcing. And obviously there may be reasons for that, but I think it makes it particularly challenging to do that cost risk benefit analysis that frankly I think is needed in today's world where we simply don't have the capability to comply with everything at once. On the flip side of things, we're seeing a very much stricter and lower threshold for a presumption, at least, of regulatory breaches from a regulatory side. So the best example of that many of you will have noticed potentially is the UK and the EU's move towards presumptions of serious risk for a chemical breach, including in the context of the PRISM risk assessment or the SAGA risk assessment, formerly the RAPEX risk assessment practices. So if we're already starting from a presumption of serious risk and we're already presuming that there's a serious issue here, then obviously it makes it much more complicated going forward to deal with those types of issues. We're also seeing an increased feeling of duty or responsibility and transparency towards consumers and the public. I think that goes alongside what I mentioned before about the expectations of the consumer. And one of their expectations is undoubtedly to be able to have information about the products they're using and to be able to have some sort of say as to the public authorities that are dealing with the safety of these products in the first place. So we're seeing an increase in requests to regulators, also in formal contexts such as the freedom of information requests. Many of you will have heard who have spoken to me about this war story example I have in respect of a very large class action we were doing where the claimant was denied disclosure in the context of the civil case, which was very unusual at this pre-action stage, a win for the defendants. But they went straight to the regulator and asked them for a copy of the documents that they had been denied in the civil court case. And because the regulators felt duty bound, it was redacted, but they were still able to obtain a copy of that through the regulators. And that was notwithstanding the fact, obviously, we made the regulators aware of what had happened in the civil courts just the day before. So there's a real need for the regulators at the moment, I think, to feel that they are serving the public, and that is obviously their function. And they're leaning into that currently, including in terms of divulging information that you have given to them in the context of confidential discussions sometimes. There's also an increasing dialogue between regulators and consumers. So some jurisdictions have always had this historical open line of communication and open line of action based on that communication. So the ACCC in Australia is a very good example of that respond directly to complaints. Some other examples in the Middle East and Switzerland. But we've also seen that change start to take more footing in the EU. For example, the new EU Safetygate direct consumer complaint mechanism is able to be used. And I've seen that used, companies have had to respond to it, and I've seen some of the consequences that flow. There is more of that direct consumer regulator relationship developing, and I think that trend is only going to increase as we continue to get into this pro-consumer environment in which we now exist. Along the same lines, regulators are now feeling the need often to be more punitive and to be demonstrative in terms of their actions designed to have a dissuasive impact. So Australia, again, the ACCC, many of you will know, they're very, very active regulators, or they're recognised as such. And there's been a number of different examples recently of them having quite hefty penalties and public enforcement actions, including in their main policy areas. The US also has had some unprecedented prosecutions and now fines in respect of late reporting that we wouldn't have seen in these spaces just a couple of years ago. And that's just a few examples to give you. There are also many others in terms of at least investigations that we've been involved in that might not turn into formal prosecutions, but which certainly are being undertaken more freely when companies have breached or allegedly breached any sort of requirement in this space. And then on the back end of things, liability trends. So this is where all of the work that we've seen before and all of these issues really come to roost. So a lot of what we're seeing now is the very, very close and intimate relationship and overlap between these regulatory steps and the civil litigation. I mean, it's always been the case, there's been a relationship between them, but now more than ever, a regulatory finding against a business or a regulatory step like a recall is increasingly being used as the basis for consumer cases or claims, particularly on class action style cases. So many of you will be aware of some of those revisions in the EU Product Liability Directive. They speak exactly to this point, that there is now a reverse onus of proof if a product is non-compliant with legislation. We all know that technical non-compliances happen on a daily basis and don't necessarily impact safety. That's not what's being said. It doesn't matter. A technical non-compliance theoretically could be used as a basis for a presumption of defect for a product liability claim. And that's really quite difficult because you're in a position of arguing against proving your product is not defective rather than the other way around. There's new types of claims that consumers are bringing. So some of the regulations are being created to create direct rights of damage for consumers if you breach product regulations. And also EU courts themselves are broadening the circumstances in which consumers can really sue in respect of a breach of regulation. The Dieselgate cases across the UK and the EU, in particular Germany, are really good examples of that. And that's very unusual because ordinarily, as we've spoken about, enforcement actions are what you'd see for a breach of regulation. Now we're seeing a direct right of consumers. So if you couple together what we know about technical breaches of product regulations, which happen frequently, alongside this growing trend of having consumers to be able to collect directly for that breach, as well as a presumption of defect for product liability cases, we have a really perfect storm for what is going to be significant litigation. That sitting alongside this focus on consumers' satisfaction or the link between consumers and regulators, we really have a very litigious landscape that didn't exist 5 years ago even. One of the other fundamental changes in litigation trends is to do with the development of a collective action and class action regime in many jurisdictions. Again, the EU and its representative action directive is a really good example, but other jurisdictions such as the UK, Australia, and of course the US, which have well-used class action system, continue to do litigation at scale and will continue to be leaders in terms of the types of class actions we see. I think what these global developments in terms of other regimes means is simply that you can carry across those actions. So when we were leading the Dieselgate cases in the UK for 2 of the 13 manufacturers here, all of the pleadings essentially were copied and pasted almost from US pleadings. So that's the type of copycat or carry across cases that we'll see in respect of these types of claims. We're also seeing a broadening out of the heads of damages that are available. In other words, the types of harm that consumers can claim for, and these are very relevant to product compliance functions. Pure psychological harm and data loss and corruption. They're introduced in many different ways, including, for example, the EU Product Liability Directive, but that has very direct impact for how we're dealing with consumers at a consumer care level, and also what we're doing with their data and what it means to lose it or corrupt it in this context. It's a very interesting new development that has very wide-ranging consequences. Also, we know that liability is broadening generally. There's new entities, new product types. There's all sorts of component parts that are being included, and that broadens your overall legal exposure, which is particularly problematic for all of the reasons we've discussed up until this point. One thing I don't have on this slide, and I'm not sure why, because many of you who speak to me will know it's one of my favorite topics to speak on this, is litigation funding. And I just want to spend a few minutes on that, because for those of you who don't work regularly in the courtroom and don't see this on a daily basis, I just want to emphasize the fact that when we're talking about litigation risk in a consumer case, I think most companies must assume that it's the consumers that are the real threat to bring these types of proceedings. But if I'm honest, often those consumers are simply a vehicle for both claimant law firms and also litigation funders to bring these claims. And litigation funding is, as it sounds on the tin, providing funds in order to allow someone to litigate a matter. And these are usually provided to claimant law firms to pursue big consumer class actions. That's happening all over the UK in particular, all over Australia, and to a more limited extent because of caps on that practice in the EU. And essentially, it's a business, as it sounds. Litigation funders are there to make a profit. So they're looking for a case that has public interest, is likely to draw headlines, and is likely to give them some profit at the end of having funded this case on behalf of the claimant law firm and or consumers. And I think if you put that into context and realize that often these litigation funders are much better heeled than the companies they're suing, it makes more sense when you're considering risk. Because what is a risk to a consumer may not be a risk to a litigation funder or even a claimant law firm, who, by the way, spend a lot of their time scouring the internet to look for issues and non-compliant products alongside regulators to try and find a good case to pursue with their litigation funders. So I think that people, when you understand that more business context, might start to look at risks slightly differently. And I do think that's an important factor to consider when taking into account the risk assessment you have to now have when deciding what your compliance profile would look like. So I'm not sure how many of you have experienced those risks, those issues rather, and disruptions, but it would be interesting if you share your stories. And I'm sure what I find, particularly at compliance and risks events, when we have lots of industries together, is that they're shared experiences. And when you think that it's something that's unique to your industry, it's often actually something that you can talk to cross industry and gain some insight potentially. And we certainly find that from our practice, that working across all the industries certainly helps to advise other industries in that regard. But what does all this actually mean in terms of legal exposure? These types of issues can sort of cement in many different ways in terms of legal exposure. One of them is regulatory enforcement, as we've discussed at length about that enforcement action taken by regulatory authorities. Another is in terms of civil liability, which again is something that you've heard me repeat several times, and which tends to be with parties owing each other duties, including consumers themselves. One that is less talked about, and actually I saw in the German press just today, there was a big discussion about some allegations of lawyers not advising their clients about criminal liability that was likely to flow from a product safety breach or a product regulation breach. That is very much a real and live risk, and that criminal liability generally attaches to the directors and officers of the company, but in certain circumstances can attach to someone else. We all saw those clips in particularly, for example, some of the Dieselgate matters in France of people being marched off in orange jumpsuits. It's not obviously it's usually saved for egregious issues, but it's not as foreign a concept as it was 5 to 10 years ago. So I think whilst not scaremongering, when discussing these risks with management, it is very important to realize that does happen and it is possible. And as I said, what you don't see, because of course it's confidential and we can't talk about it, is the number of times you almost escalate to that point where there's been an investigation that hasn't amounted to an actual prosecution or an actual incarceration. But, it's a very stressful and damaging time for the company. So it's best to try and mitigate that risk as much as possible. And then something that's not technically legal, but which I think is under discussed, is reputational damage. Of course, all of these issues with regulatory breaches and product liability claims come with huge public attention and negative. And as I mentioned, that's one of the criteria, in my experience personally, that litigation funders actually look for. Is this going to make headlines? Is it going to be uncomfortable for the company who's dealing with these issues? So they tend to go for issues that have more of a public interest test, like ESG related issues, or something that speaks to the public conscientiousness rather, in terms of what might be an appropriate attention grabbing headline in a social newspaper essentially. And again, often those cases are brought with the knowledge that the leverage of that reputational harm is enough. It doesn't need to be that the substance of the case is surefire. It can be the fact that because of the pressure that's put on those companies, and I can say every time we walk out of the courtrooms, there's hundreds of cameras sometimes capturing those coming out of the courtrooms. It's designed to put pressure on companies to settle. And if that's perceived by the claimants or the litigation funders as being sufficient, that might be enough to warrant a claim being brought, knowing that they won't even need to see the end of the trials. They'll be able to to obtain a favourable settlement, just based on the company wishing for the issue to go away without their reputation being more damaged than it was previously. And these types of issues can occur at any time. And I think, you know, often they're led by an incident or an accident that takes place, and then some sort of regulatory non-compliance is discovered. We have to discuss and advise companies on the types of legal obligations that may be triggered, including, for example, regulatory reports to authorities, or indeed consumer-facing actions or corrective actions generally. That sometimes can lead to an inquiry by a regulator, which might lead to a prosecution or an enforcement action of some nature. Once there's some sort of regulatory finding against a company, that can often flow in terms of civil liability claims. It's very easy once you have that base finding, particularly today, in today's environment, to really have a long, protracted litigation piece. And then a topic that's talked about less, but I think is also very relevant, is public law matters such as inquiries, inquests, select committee hearings, even those technically fact-finding missions. Again, I acted in Grenfell Tower inquiry. Those were all used as a springboard for civil liability claims. So I don't think that companies necessarily appreciate that always, when maybe these days, yes, but even 5 years earlier, not as much, that whatever you say in those contexts, even not a particularly high profile case of that nature, will still have ramifications in terms of your legal exposure on the other end of things. So it's important to remember that. So I don't want to sound like all doom and gloom to talk about all of the issues, but I'd like to try and give you a taste for some of the mitigation strategies. And candidly, they're not rocket science, the mitigation strategies, but they're things that companies don't necessarily do with much rigor or diligence, or they do once and then forget about and don't do afterwards. What I find disappointing in my role is the amount of time that's spent on defending things, and not perhaps enough time, resource spent on actually preventing things from escalating to that point. Because what I always say is that there's limited things that can be done once you're in a courtroom, in the witness box with the facts that you have in terms of your underlying compliance strategy. So I cannot emphasize enough, one of the most important things that can be done, particularly in this day and age, is to review and sometimes push back on your supply chain in terms of onboarding them. I appreciate the practical difficulties of having limited options, and I appreciate the fact that you may not ever say to me that you can get these suppliers to agree to the supply chain agreement that you're proposing to give to them. But what I would emphasize is it's worth trying as much as you can at that onboarding process. By the time you have an issue and that component part or something else happens, it's very difficult for both parties, including any one component manufacturer. The reverse is true. It's very difficult to disentangle who's responsible for what if you don't have that properly in place. And frankly, the leverage used to try and obtain the best position for each party is at the beginning, where there is no live issue and there's no pressure on anyone to decide that. Companies tend not to have sophisticated onboarding processes or due diligence processes, or they're aware of an issue and they don't follow it through because it seems like they just need to get this product manufactured. Appreciate all the commercial realities and all of the practical realities that we've discussed, but if there was one thing that I would say that causes the most grief at the end of the product litigation life cycle that we've worked through, it's that. It's that there aren't clear lines of responsibility, and there's not clear indemnification principles, and there's not really a clear understanding of who is responsible for what, and that's not fair on either side of the equation, the component manufacturer, the supplier, or the manufacturer who's named on the product. So I would spend resource in considering whether that's been done in your company or if there's more that you could do in that space, and maybe have a look at some of the contracts that you have in terms of the wording, particularly in terms of indemnification, particularly in terms of due diligence obligations, and particularly in terms, I think, of auditing as to what's appropriate and what needs to be reported back in terms of changes to the main manufacturer, because that would save everyone a lot of time and hassle. The other task is to really continue to check your product portfolio. And by that, I mean to continue to check what requirements attach to what products. And again, I mean that across sectors, and I mean that across groups within the company. So as I mentioned before, one of the biggest gaps we see is with obligations that tend to fall between the cracks. It's neither strictly ESG nor strictly product, or there's other examples, trade, competition, those types of obligations where it might be an area where it's unclear as to who within the organization is required to deal with that issue. I would take time finding what we think those issues are and deciding what applies to the product, and then more importantly, who is responsible for making sure it happens, so that we have a good position to explain if anything is to happen later on. The third thing is really to consider all of these developments and growing litigation risks. So this is why we work so closely with compliance and risks, not only as knowledge partners, as Kerry kindly mentioned, but really as actual partners, because a lot of our clients are shared clients for the reason that it's important to track your regulatory developments. And then on top of that, it's important to consider what type of risks eventuate in respect of these obligations. And that may be penalties. It may also be enforcement practices in general, which, as I mentioned, are increasingly difficult to predict, but which still can be done. And then some other factors, like, for example, the size of the entity that exists in that jurisdiction, other legal factors which may be relevant. I personally don't see any companies that I work with, all of whom are very diligent and wish to comply as much as possible. It's not physically possible these days to do everything at once. So this is an approach that has to be taken, but it needs to be taken with some rigor, and tracking and understanding what the obligations are, and then matching it with a risk assessment is very important in terms of deciding what to do next. And the last high-level suggestion is really to review crisis process managements and protocols, or even, frankly, to run a simulation. We do a lot of product recall simulations with companies, including with other logistic companies with whom we work. Because what we tend to find is when a crisis happens, it's not actually as easy as it may appear for the groups to communicate with each other within a company. It's not very obvious where information may come from, and all of these things are very relevant in that respect. So yes, that is an important thing to do when you're considering what is possible in the realm of product crises. And I think what also is important is if you have a written product crisis management protocol, which I would suggest, because as I mentioned, it's important to be prepared, but it's also important to follow it. In the event of some sort of crisis, if a regulator is going to criticize you, it's also important to have the strategies to implement whatever you're suggesting. That usually should be a very well thought out process in terms of how you deal with these crises. Simple things like traceability come to bear in these types of exercises. You would be surprised at the types of very basic issues that are turned up and that are a complete shock to the companies that are involved in them, because they have very sophisticated processes for lots of things. But there are a few things that become very obvious if you do a simulation of a crisis to see what actually happens in that context. And I don't need to tell all of you, because many of you I know will have product compliance functions, and I've been saying this for many years, but now it's more important than ever that as much resource as possible, and tell your management, happy to give them some statistics and figures if it's useful, but jokes aside, it's so important. Product compliance is the solar system to all of these other issues. It's the gravitational pull that is very important for all of these other issues we've talked about. Compliance is really going to underpin all of these other risks, as you've seen. So really, if I were to say which area should you spend the most resource and time on, it is product compliance. They need to be as correct as possible. As you've heard me say repeatedly during this presentation, technical non-compliances are no longer really acceptable, really. It's really as important as possible to be as close as possible to what you need to comply with, bearing in mind what I've also said, that it's impossible to do all of that at once. So really, I think it's important to consider what the process is, to have a dedicated team. Frankly, in a defense case, one of the most persuasive things to say is just the time and effort, resource, structure that a company has in place in respect of product compliance that gives a signal to the enforcer, to the regulator, to the courtroom, to the consumer, that you are serious about this issue and that you've undertaken a exercise to invest into it. So really do take the time to consider that. If your management needs persuasion, as I said, you can give them all of the examples of what we're seeing in this space, which is really increased in the last 5 to 10 years. But also make sure that you're writing things in an appropriate way. And I'll come on to document management, which is a whole topic into itself. But also to have regular meetings and discuss this, document it properly, but have those regular meetings and have a proper escalation process where it no longer becomes a product compliance issue and it escalates to something else. Over the many years that I've worked in this area, I would say that is probably the biggest cause of litigation itself, is where there's an issue that's known by a product compliance department that doesn't make its way up the chain and remains just that and doesn't get addressed on the other end. And then something happens in terms of consumer facing issues and we have a perfect storm for a very successful case against the company.
Sarah, this is such a good conversation, but I just want to let you know we have about 4 minutes left.
Yes, thank you very much. So the last mitigation strategy, or the second last mitigation strategy, is really just your documents. And one of the most fundamental changes in the European Product Liability Directive is to require, at a continental European level, which is very unusual, to disclose documents. So they're more important than ever. And if that disclosure is not considered appropriate, or the documents that you're disclosing, which are technical documents, are not understandable, you have a presumption of defect. So it's very important for product compliance functions to get this right. But also think about the documents you're taking to document an issue, to escalate an issue. Think about those protocols I've mentioned, consider the warranties and representations you're making, and also just think about the insurance you have in place and the liability provisions you have in contracts that I've mentioned. Those are very, very important factors and are often overlooked until something goes wrong. And then frankly, as I've said, it's too late. If you wish to talk about documents, that is, as I said, and Kerry's just given me the 4-minute warning, but there are so many things to say about contracts and documents, particularly document creation, particularly with the new disclosure obligations. So do reach out to me if you wish to discuss that further, because that's a very important topic. And then if we look at dispute management and resolution, I think the first thing to say is have a really powerful consumer care team. That is so important, to have that first interface with consumers for all the reasons I've said. It's always been important. It's more important than ever. And then know your potential claims and claimants, including the litigation funders that are looking at you as a target for these types of very large class actions that are attention grabbing. And have some pre-litigation mechanisms in place. And don't just do this across one jurisdiction. Do this across the whole world. And George, to answer your question, yes, we definitely cover Latin American countries. You're right. They're very active with active enforcement as well. But definitely know the landscape that you have and make sure that you're dealing with all of it. And my advice is to have as uniform approach to risk as possible so that you don't have disproportionate profiles to manage in different jurisdictions, but you do have to adjust based on the appetite of the regulator, which, as George pointed out, LATAM countries have very active enforcement practices and litigation practices, and other jurisdictions as well. So where is this all headed? I think the fact is that we're in a perfect storm at the moment. We've been talking about this for years, about the fact that product liability, product compliance breaches are on the rise, but for all the reasons I've said today, I think all of that is really coming true now. We have the perfect combination of very active, engaged consumers, active regulators who are listening to consumers, a very sophisticated liability regime that's unashamedly pro-consumer, the development of large class action regimes which are designed to bring very large value claims against companies. And then we have increased requirements on companies which are easy to breach. So we're in a world where this is not going away. We're really just at the beginning. And I would add that some of the main mechanisms I've discussed aren't coming into effect until the end of this year. So we've still got some time to see. And as for all the other jurisdictions, US, UK, EU, LATAM, Asia in particular, all of those are looking to the EU for these very seismic changes that have happened in the liability regime. If those are effective and work, then I think we can expect to see them mirrored. and continue to see this copycat litigation, which happens all of the time, often from the US to Australia next, often, and then onwards to Europe. LATAM is often before Europe, as George has mentioned there as well. So, yes, I think this is just the beginning of what is a very difficult time. But if you implement those strategies, I think that there's much that can be done to try and get ahead of these risks. So I hope you found today useful.
Sarah Jane, thank you so much for your time. It was such a good conversation. Unfortunately, we are not going to have time for questions, but if there are any put in the chat, we will be happy to respond to them after this call. But thank you for tuning in with us today. We hope you found the presentation helpful. We look forward to seeing you in upcoming webinars. Check out our resources on the resource section of our website for the latest white papers, blogs, webinars, and so much more content coming up. Our next webinar will be April 22nd, Chemicals Quarterly. It's always a packed webinar and really important conversation. So we hope to see you there. Thank you.